department's document identification and review protocols, it consisted of multiple layers of review and quality control designed to ensure compliance under the Act and protect victims. On top of the review protocols that the department had in place, the United States Attorney's Office for the Southern District of New York employed an additional review protocol to ensure compliance with a court order requiring United States Attorney Jay Clayton to certify that with respect to certain materials, a large quantity of the materials, a rigorous process was undertaken to protect victims against any clearly unwarranted invasion of their personal privacy. The department's collection effort resulted in more than 6 million pages being identified as potentially responsive, including department and FBI emails, interview summaries, images, videos, and various other materials collected and generated during the various investigations and prosecutions that the Act covered. We erred on the side of over-collection of materials from various sources to best ensure maximum transparency and compliance, which necessarily means that the number of responsive pages is significantly smaller than the total number of pages initially collected. That's why I mentioned a moment ago, we're releasing more than 3 million pages today and not the 6 million pages that we collected. I want to address what we didn't produce. The categories of documents withheld include those permitted under the Act to be withheld: files that contain personally identifiable information of victims or victims' personal and medical files, and similar files, the disclosure of which would constitute a clearly unwarranted invasion of personal privacy. Any depiction of CSAM or child pornography was obviously excluded. Anything that would jeopardize an active federal investigation. And finally, anything that depicts or contain images of death, physical abuse, or injury, also not produced. Although the Act allows for withholding for items necessary to keep secret in the interest of national security or foreign policy, no files are being withheld or redacted on that basis. Further, as we previously stated in our December 19th letter of last year, the department withheld or redacted files covered by various privileges, as we always do, including deliberative process privilege, work product privilege, and attorney-client privilege. As you all know, under the Act, the department must subsequently submit to the House and Senate committees on the judiciary a report listing all categories of records released and withheld, a summary of redactions made, including the legal basis for such redactions, and a list of all government officials and politically exposed persons named or referenced in the Act. We will do so in due course as required under the Act.